Good morning, everyone. It is just such a pleasure to be here, and thank you so much to Rick and all the Australian Institute of Criminology team for the invitation to speak this morning and attend what's been such a fabulous conference. It's so nice to be in person. Victorians in particular really say that. I would like to begin this morning by acknowledging the traditional owners of the lands on which we're meeting, the Ngunnawal people, and pay my respects to elders past and present, and also acknowledge all First Nations people that are here today. In the domestic and family violence space, and particularly the coercive control space, we have been so fortunate in recent years, but really over decades, to hear and learn from First Nations leaders. We have to listen to what First Nations communities are saying in this space, and I've been really fortunate to learn from them in recent years. I would also like to just start with a couple of other acknowledgements. The work I'm presenting today is very much a team effort, and fabulous colleagues that I work with at Monash and Griffith University. On this work specifically, I've been working with Sandra Walklate, Silky Meyer and Ellen Reeves. All mistakes will be mine, but all brilliance is shared. The work also presents the views and draws on the expertise of over 1,200 victim survivors who incredibly generously shared their experience and their views on the criminalisation of coercive control with us. We were astounded by the generosity and the willingness of victim survivors to engage in this work, and obviously cannot present everything today, but just want to acknowledge their contribution. I have been thinking about coercive control for a number of years now. It's become quite a hotly contested space in recent years. Many people in this room may know that I've been quite one of perhaps the louder voices urging caution as we consider the criminalisation of coercive control, and really that stemmed from a body of work that I've done looking at the ways in which the criminal justice system has not delivered fairly or justly for victims of gender-based violence, and a concern as to what expanding the remit of the law will do for victim survivors. But one of the things that really struck me in working in the coercive control space was that we know very little about what victim survivors wanted. There have been a couple of incredible and very loud victim survivor advocates who have been given a platform, but we know that 1 in 3 Australian women experience domestic and family violence. So to be drawing on the voices of a handful of victim survivors as if that represented all sat really uncomfortably. So this work that I'm presenting today is part of a body of work that we're doing to ensure that lived experience and the expertise of those who have experienced victim survivors is contributing to this really important policy conversation on how we can best respond to coercive control. I've also been involved in, over the last year, which has been a very busy and fun time, in the development of the National Plan, which has now been launched, and then also on the AGD's Trusted Advisory Group for the development of the coercive control principles, which is so fantastic after, I think, a year of debate where all the states and territories have been extremely divided and really working in silos on what their response to coercive control will be. It's been so nice to come together and have the leadership of COAG developing national principles of coercive control. So I'm really hoping that through those principles we'll move forward and be learning from each other and have that consistency. We know that perpetrators don't work within borders, and we know that victim survivors often move states and territories quite often for safety reasons. So it's really important that we have national agreement and consistency in this space. So I've probably done most of my background now, but as many of you would be aware, there's been a lot of debate in recent years about the law's response to all forms of domestic and family violence, but in particular recently we've seen a focus on coercive control. Coercive control, for those in the room that are less familiar with it, is a term that's used to capture the long-term and the ongoing nature of a wide range of different abusive behaviours. What coercive control draws attention to, which is critical, is that abusive behaviours occur as part of a pattern over time. When you pull out any one single incident, it may not appear significant to someone outside the context of that relationship, but within a pattern of behaviours, those behaviours are designed by an abuser to instill fear, to control, to coerce, to isolate and to attack every aspect of an individual's autonomy and well-being. One of the examples when I, as part of a Churchill Fellowship in 2015, I spent a month in England just as their coercive and controlling behaviours legislation was coming into effect. And I spent some time with Women's Aid who had campaigned for the offence. And part of what I was asking them is, who will this benefit? Who do we have in mind that wasn't being well served by the law? And one of the stories they've told me has always really stuck with me as an example of the behaviours and the pattern that we're talking about here. It was a woman whose husband had been physically abusive, not for some time, at the time that she came to Women's Aid seeking help. But every morning before he went to work, he would hide 3 coins around the house. And she had to find those coins before he got home, or he said he would kill her. Some days she'd find those coins in the first 5 minutes and she'd get on with her day. Other days she'd be scrambling around on the ground 7 hours, 8 hours later, genuinely terrified of what would happen if she didn't find the coins. He didn't have to do anything else to instill that level of fear and control over her life and that genuine fear for her life. And this was one of the cases that Women's Aid in particular was saying, we've had no legal response to this. If we think then about how we possibly bring that within the realm of criminal law, obviously belies some of the challenges in this space, but I think it's a good example of what coercive control is, and also why it's hard to come up with a single definition, because perpetrators are extremely creative in how they will perpetrate different aspects of this behaviour. In terms of the criminalisation debate specifically, it has quite often fallen into the for and the against criminalisation of control camps. I'm really pleased to see more recently, I think we're sitting in the grey a lot more, which is a much more productive space to be in. But Australian states and territories are all at very different stages at the moment. We have New South Wales. There is a bill that has passed the lower house, and there's a 1-week inquiry on at the moment, which we'll be reporting on Friday, which is just taking a pause and looking at what implementation would look like of that bill and whether there needs to be any amendments. Queensland, from the work of the Women's Safety Task Force and the current Commission of Inquiry that is underway, is taking the different approach that they're saying that they'll be committed to doing some of the preparatory and the systems reform work first, and that the offence will follow later. Other states and territories are at different stages. But those who have been advocating for criminalisation have really been speaking about the importance of the law in setting the standard of what is and isn't acceptable behaviour and the symbolic importance of that. They've been drawing attention to the lack of a criminal offence and attaching that to women's inability to seek help for these behaviours, that they cannot without a criminal offence, and that it minimises perpetrator accountability not to name this and respond to it within the realm of criminal law. Advocates and scholars that have been urging caution have been really drawing on body of work that shows that law reforms that have sought to, with the best intentions, to increase responses to different forms of violence against women over the last 3 decades have often brought about unintended consequences for that very category of person that they were seeking to help. In particular, there's been a focus on how this would impact in incarceration rates, and particularly our over-incarceration of First Nations communities, and also the building awareness of what this may do in terms of risks of misidentification, where police may attend an incident and they identify who is the primary victim, but that person is identified as the perpetrator. So the justification for this research was really an awareness of the absence of victim survivors' voices in these debates, but also internationally. There's been no major study of victim survivors' views on the criminalisation of coercive control in any country, despite a number of countries are well on their journey of introducing the legislation and enacting it. So we saw this as a really important gap and contribution that could be made. This study, and what I'm presenting today, is the first stage of a larger project that we're extremely grateful to the Australian Institute of Criminology for funding. We envisaged an online survey where we would gather victim survivors' voices. Part of the reason of wanting to do a first stage with an online survey is that we knew that for some victim survivors that would be a more accessible and a more safe and anonymous way for them to contribute to the research. So we wanted to make sure that we offered that. And we hoped through support from a number of different domestic and family violence organisations and networks that we could reach a wider range of victim survivors that then may feel comfortable to come forward and participate in an interview with the research team. We had said what we thought quite ambitiously, that we would try and capture the views of 200 victim survivors and then conduct interviews to get in-depth understandings of their experiences and views with 40 victim survivors. We had just over 1,200 victim survivors that completed our survey in 5 weeks. We were absolutely blown away. We then had 400 victim survivors that nominated to participate in an interview. And you have to ensure that every single person that nominates is valued and receives a reply. So there was a natural drop-off in terms of people's availability or whether they were still in a space where they could participate, but we have also conducted 179 interviews with victim survivors. And so across the 2 data sets, it really gives us the breadth of understanding and then the more in-depth understanding as well. For the survey, we knew that to understand victim survivors' views on criminalisation, we had to go back a lot more, that we needed to understand their experience, whatever they wanted and felt comfortable to share with us about that, whether they identified and knew that it was family violence at the time, who they experienced coercive control from, whether they reported to police or any other services or family and friends, and what the outcome of that help seeking was. And then with all that context around how they came to us, we asked them about criminalisation. So today I'm going to predominantly focus on the criminalisation findings, but we have this incredible body that kind of goes back and tells us a lot about women, men and non-binary victim survivors' help-seeking behaviours, tells us about the challenges people have in understanding that this is coercive control. We've heard it so many times, but certainly, particularly throughout the interviews, we just heard it continuously, relief from individuals when they were finally hit. So they went, I was so uncomfortable and so afraid in my relationship, but he'd never been physically abusive to me. So when that happened, it was a relief because it confirmed everything that I feared about my relationship. We heard about family and friends and the impacts of their lack of understanding around coercive control and how that shut off doors for victim survivors in seeking help and gaining support. And then around criminal justice responses that are at the moment predominantly based on an incident-based model, which looks for single incidents of harm as opposed to the pattern of abusive behaviours that the victim survivors we heard from were experiencing. So this is a bit of a very high-level snapshot of our survey respondents. We had a very small number from the Northern Territory, but otherwise we did have national representation. It's cut it off there. It was 39% of our respondents reported living with a disability. 21% of respondents identified as LGBTQIA+, and predominantly sat within 31 to 60, and between 30 and 40 was the largest category of age of respondents. This was an extremely educated sample. I think part of that is likely to be we're a university, sharing a university survey, we're assuming through the networks that we put it out. But we also know in other research, including research done by the Australian Institute of Criminology, that this is quite common, that often victim survivors that participate in research in this way do have a higher level of education than we may see otherwise. 3.5% of our respondents identified as First Nations. 65% were in some form of part-time, full-time or casual employment. This is predominantly a metropolitan sample, and in particular we had a very small number of people from remote and rural areas. But that's obviously incredibly important in terms of help seeking and access to justice. Our Our survey sample had experienced all forms of domestic and family violence, and it's subject of another presentation to kind of go through that. 71% of the respondents had told someone during their experience that they were experiencing coercive control, but only 38% viewed what they were experiencing at the time as domestic and family violence. So the vast majority of the victim survivors in this survey had come to that understanding later. And in particular, I think the public nature of the debate around coercive control at the time, as well as a lot of the publicity around Jess Hill's book that had come out about a year before this survey. We had a number of victim survivors that specifically mentioned either the media around the coercive control debate or Jess Hill's book as being a light bulb moment for them, that they now understood what they were experiencing was a form of family violence. This just gives some of the high level numbers, and then I'm going to move into kind of some of more of our content and qualitative analysis from the survey, where victim survivors did write kind of whole pages of information. And just before I get into the data and move through, a warning there that I have included a number of quotes from victim survivors. So for those that brings up and triggers, please do just take care and feel free to step outside if needed. The absolute vast majority of victim survivors that responded to this survey supported the criminalisation of coercive control. Just under 90% in the entire survey sample, but when we looked across female participants, male participants, participants who identified as gender diverse, and obviously there are numerous different categories within there that we need to look at and look at the differences in behaviours and understandings and views, but across all of our demographics, victim survivors supported and believed that coercive control should be a criminal offence. So what we were really interested in was the why. And what? What did victim survivors think that the criminalisation of coercive control would give them or would deliver for other victim survivors? So as a follow-up, I'll quickly these are just some of the responses that people put when we asked them to please explain their views. In terms of support for criminalisation, people predominantly just spoke with enthusiasm about the need to get this done and to get it done now. And there was a sense of urgency that this was needed, and the speed with which they wanted to see the legislation introduced. Amongst the smaller percentage of people that opposed criminalisation, the responses were a lot more complex. And they spoke about the importance of focusing on other points of the system that had quite often failed them and that they had wanted to seek support from. A lot of victim survivors shared their own negative experiences with the police and the court system and spoke about that framing their lack of confidence that that same system would be able to respond to the nuance of abusive behaviours that can occur within the context of a coercive control relationships. And they spoke of the limits of criminal law reform, kind of not believing that it would be able to achieve safety and justice. And there's some of the quotes from those victim survivors. What we asked as a follow-up question was, what effect did victim survivors think a criminal offence of coercive control would have? Interestingly, that it would bring justice for victim survivors was the least selective response amongst those who favoured the criminalisation of coercive control. Victim survivor safety, improving victim survivor safety, was the next lowest response selected. Respondents could select as many as they thought were relevant, and predominantly victim survivors believe that the criminalisation of coercive control will increase community awareness, that domestic and family violence is not only physical behaviour, and that they'll increase community awareness of this as a form of domestic and family violence. There was a number of respondents talking about that it'll allow police to respond to coercive control, that it'll send a clear message and achieve enhanced perpetrator accountability. So I just want to go into these different justifications a bit more, because after this we then asked victim survivors to explain their views on what the criminalisation of coercive control would achieve. So the impact on improving community awareness was seen as the key benefit of criminalisation. And we can see from one of the victim survivors here who said, if it were criminalised, it would be well known that it's absolutely not okay. At present, there's grey areas that our society finds acceptable, mostly to do with skewed ideas of what constitutes a healthy relationship, not to mention skewed ideas on what's acceptable for men and women. Criminalisation shows that at no one level we as a society know that coercive control is wrong. So a really clear demonstration there of talking about the symbolic power of the criminal law. The new offence was viewed as the vehicle through which community awareness would be achieved. Victim survivors said that they thought there was then the chance to enhance referral pathways because those across the system, but also family and friends, would be more aware that these are forms of domestic and family violence that must be taken seriously. A number of victim survivors reflected on telling family and friends what they were experiencing and being told, this was just the messiness of a relationship or he's never hit you, you're lucky, and that there was no offer of support or validation for their experience. And they felt that that would change if this was considered criminal behaviour. In terms of impact on victim survivor safety, as I mentioned, there was quite a drop-off of victim survivors from those who supported the criminalisation of coercive control to those that believed that it would increase victim survivor safety. And this point has obviously been a key focus of much of the debate around coercive control, particularly with reference to the New South Wales Domestic Violence Death Review Network's report, which showed that in the vast majority, if not all, cases of intimate partner homicide, there was a history of coercive control in those relationships prior to the act of homicide. So we have seen a number of governments really talking about the criminalisation of coercive control as saving women's lives and improving their safety. Victim survivors who did believe that criminalisation of coercive control would improve safety outcomes, and there are obviously over 600 that did, talked about that enhancement of referral pathways and that they felt victim survivors would be supported to leave an abuser more readily if the behaviour was understood as criminal. They spoke about the criminal justice system as playing a key role in preventing the escalation of violence and that this would provide a clearer interruption or opportunity for interruption in violence that was ongoing. And that they spoke about the need to ensure that the law is equipped to hold these perpetrators to account, that looking at isolated behaviours or incidents of harm that perpetrators were doing was allowing the myriad of other behaviours of perpetrators to go unnoticed and to be not held to account. In that respect, there was a number of victim survivors that fell into a similar, that spoke about the impact that criminalisation may have on perpetrator accountability and the opportunities to hold perpetrators to account. And I think we've seen a really important shift in recent years, both through work that's been occurring at the national level with the national outcome standards for perpetrator interventions, also through the Victorian Royal Commission into Family Violence, that really held as one of the key principles the need to hold perpetrators to account and keep perpetrators in view. We know that perpetrator accountability at every point of the system is essential, and victim survivors saw the criminalisation of coercive control as one way through which that may be achieved and a clear indication of the seriousness of the offending may be delivered. But on the flip side of that, there were serious concerns amongst victim survivors and an awareness of the risks of misidentification and the impacts of criminalisation. Interestingly, and I think this came out perhaps even more so in the interviews, victim survivors often reflected on their own experiences through the criminalisation and then an awareness of how that would impact others, and particularly how that would impact victim survivors differently from diverse communities and in particular First Nations communities. Victim survivors were particularly concerned that police do not have the specialist understanding of domestic and family violence to be able to respond to an incident of coercive control. Numerous victim survivors shared their own experiences of when they had been the victim of physical violence that left visibly obvious and identifiable injuries and the insufficient responses that they had received from police in those occasions, and really questioned how all the other behaviours that were much more difficult to evidence, how police would have responded to that. And we're certainly seeing through the Queensland inquiry into police responses to domestic and family violence at the moment, the limits and the significant work that needs to be done to ensure safe practices. Victim survivors described a fear that if an offence had been in place at the time that they were experiencing coercive control, that they would have been misidentified as the predominant aggressor and that it would have been used against them. And there has been a body of work done on other aspects of the law and by colleagues such as Heather Douglas, looking at what they've termed systems abuse and the way in which perpetrators use the system and use the different angles that they have available to them within the system. Particularly, we've seen it in the family law system, to continue to perpetrate their abuse. And for many victim survivors, they reflected that they thought this offence would be another tool in the toolbox of their perpetrator to continue to enact harm. For those victim survivors that didn't support the criminalisation, but interestingly for a number that did, but in their own case reflected on the limits and the negative impacts of the justice system. These really weren't the dichotomous categories that I think we often put people into in the coercive control debate. But victim survivors spoke about their distrust of the police, and I've already spoken about that in some detail, their own experiences with the police. And what we know and what we've seen over years, particularly in the sexual violence space, but it's certainly emerged for this cohort of victim survivors, they spoke about the trauma of engaging with the criminal justice system and what that would mean for those victim survivors that's perpetrators went through a trial. And one of the questions that we asked victim survivors that supported the criminalisation of coercive control was that if their case, if coercive control had been an offence at the time that they were experiencing it, would they have been willing to give evidence in court? The number of victim survivors went, "Oh God, no, I could never do that." But I'm sure other victim survivors will have better supports than I did, or I'm sure other victim survivors could do a better job than me. Like, it was amazing to see how many victim survivors kind of had what we know that so many people hold, but this idealised view of the ideal victim, and this will serve them really well. I'm sure they'll be able to do it, but God, no, I couldn't. Leading to on the question of giving evidence in court. Victim survivors really overwhelmingly expressed a hesitance to provide evidence in court. And I think the number that said, it's very easy to show bruises and to show physical injuries. How do I show what he did to my core, to my whole understanding of myself? And that for them was the biggest impact of their experience. And we've really seen this as the offences rolled out in England and Wales, that since 2015, the vast majority of convictions, if not all, have been in cases which have a physical violence element to them or a digital element, where evidence can be put forward to show the digital stalking or the digital abuse behaviour. As I mentioned, people didn't fall in easy categories, and it wasn't that those who supported criminalisation thought that the law was a perfect vehicle for seeking safety and justice. And I really think herein lies so many of the lessons of how we need to move forward for those states and territories that will criminalise coercive control. As one victim survivor said to us, it needs to happen, but the courts are not ready for it. They're already clogged up. So they need to be prepared for it, and magistrates need to be educated. They won't cope with coercive control without education, and this will be even more damaging to victims. My big question is, how do you prove coercive control? Far too often I hear stories of the abuser playing the victim and slapping their victim with a retaliatory order. How will it work with coercive control? So what does all this tell us about safe implementation of coercive control laws? Because we certainly know that in some Australian states and territory jurisdictions, that is the path we're on. And I think it's absolutely critical that we heed the warnings and the lived experience expertise of victim survivors in how we design and critically how we implement these laws. I am aware of the political will and the reality that there are several state and territory governments that want to have that moment of announcing that they are the first or that they are the next jurisdiction to criminalise coercive control. But we need to take time in implementation because there's so many aspects, as we hear from victim survivors, of these laws that will cause more damage and trauma for victim survivors if we don't get this right. And a key question, if we rush this, that we have to ask is how many victim survivors are we willing to send through a system before we've done that implementation work, before the education and training has been delivered at a whole of system level. We know from the work of the Domestic Violence Death Review team that there was that overwhelming presence of coercive control in the lives of victim survivors prior to their deaths at the hands of their partners. To prevent those, the law will only ever be a reaction. We know that for so many people calling the police, we're already at crisis point. There's already been so much trauma and significant abuse experience. So how do we set up a system that can intervene earlier, where there's support pathways in place well before a criminal justice system is needed, so that we ensure that the cases that get to the courts are a much smaller number of the myriad of cases. And then importantly, and I think this is what I've found extremely encouraging about the recent work on the COAG National Principles on Coercive Control, is that it draws our attention to prevention. The criminal justice system is not a preventative tool. We know that. So we need to understand and we need to invest in prevention and stopping coercive control, not just looking at the ambulance off the end of the cliff. So I do think that victim survivors' understandings can tell us quite a lot about what we need to do in the implementation phase for those states and territories that go towards criminalisation. We need to improve police risk identification, assessment and management processes. Police need to be specialist trained in how to identify coercive control when they attend an incident, to understand the gendered patterns of coercive control, to assess the risk and to manage that. And really, that risk identification, assessment and management needs to be across the whole of system response to coercive control. Anyone that comes into contact. The number of victim survivors we heard from, that the police were well down the list of people that they told. There were so many opportunities to provide a referral or a response before it came to the attention of the criminal justice system. We need whole of system training that will validate and affirm the seriousness of this form of domestic and family violence. And I think certainly, even for those that are urging caution, this isn't about saying that we think this behaviour is okay. We need, as a community, as a whole society, to understand the harms of coercive control. And that community awareness work is really important. I don't think it can only be done through the criminal justice system. I think there's far bigger pieces around education and training, but it's absolutely essential. Consideration has to be given to how the net widening of the realm of criminal law will assist in improving accountability and what that will mean in terms of responses to breaches of intervention orders. And we need to ensure that that is done. The impact on First Nations community, as well as a range of other communities, needs to be better considered and considered with community. And we know that a number of the ways that governments have been seeking information so far, that these are not processes that often different diverse community groups feel comfortable participating in. So there needs to be a lot more creativity and trauma-informed understanding of how we go about seeking that information. Police guidelines and specialist training will need to be developed from the outset to minimise misidentification of victim survivors. And critically, we have to monitor the implementation and the outcomes in real time. We don't want to wait 2, 3, 5 years to go, oh, I wonder how many people were charged and what the conviction rates is, and just show those numbers. We need to understand the cases that sit behind that, because that will help us to learn, to develop and to refine the laws that come in. And I really hope that states and territories will work together on that and share the learnings. We also know that the introduction of a new offence of this scope is going to significantly open the remit of who comes to the attention of the criminal justice system. So we need to ensure that police and courts and legal services and the services that support victim survivors as they go through the criminal justice system are significantly resourced to meet the needs of victim survivors, and that there's really careful consideration given to what the evidentiary requirements will be and what that will mean for those victim survivors that give evidence in court. We can't be sending victim survivors into a system that will re-traumatise them. And lived experience expertise should be embedded at each point of the process. And I know that across Australia we're getting a lot better at doing that, and I think we need to continually think about what it means to be embedding those voices at the table, the design table, at the implementation table, at the monitoring table. And then I think there's a moment to step back, and this has been something particularly myself and my colleague Sandra Walklade have been thinking about. Like, what does this tell us, this study tell us more broadly? If we take away the focus on coercive control, what does it tell us about victim survivors' understanding of the purpose of our criminal justice system? So many victim survivors, the vast majority, saw this as a community awareness system, not a justice system, not a safety system. And I think that's an interesting piece for us to keep in mind in all the work that we do around justice system responses to domestic and family violence. When we design system responses for victim survivors, let's keep what they want from it or what they expect from it at the front of mind. Thank you very much. That is our project website. As I said, we have a huge amount of data that we are wading through and making sense of at the moment, and the interview data, which provides a lot more depth than our survey data, we're writing up at the moment for our AIC report. So really looking forward to being able to share that as well. But thank you so much for the opportunity to share these findings with you.